In this lesson, we're continuing our discussion of subject matter jurisdiction. Specifically, we're going to focus in on supplemental jurisdiction under 28 U.S. Code Section 1367. But before we get into it, remember, we can start with our big picture basic requirements. Remember, here we say, to hear and decide a case before it, a court generally must have subject matter jurisdiction over the particular type of case before it, personal jurisdiction over the defendant, and proper venue based on locality. Of course, in this lesson, we're continuing our discussion of subject matter jurisdiction, and we're really thinking about subject matter jurisdiction at the federal level. Is this the type of case that a federal court has the authority to hear and decide? Remember, here we say, other than subject matters exclusively allocated to federal courts by law, there are generally four main ways for a federal court to obtain subject matter jurisdiction over a case. We have federal question jurisdiction, diversity jurisdiction, supplemental jurisdiction, and removal. And up until this point, we've been focused on federal question jurisdiction and diversity jurisdiction. These are the main two ways a federal court obtains subject matter jurisdiction over a case. And before we jump into supplemental jurisdiction, it's very important that we have a firm understanding of federal question and diversity jurisdiction. If we don't understand these concepts, supplemental jurisdiction is not going to make any sense. Supplemental jurisdiction is an extension of federal question and diversity jurisdiction. So if you haven't seen our lessons on federal question and diversity, or you're just not comfortable with those concepts, I'd go back, watch those lessons first, and then you're going to be ready to go for supplemental jurisdiction in this lesson. But with that, we can just jump right into it. What is supplemental jurisdiction? Here we say, when a federal court has subject matter jurisdiction over a claim, supplemental jurisdiction allows the court to hear additional claims that are sufficiently related to the original claim, even if the additional claims do not independently satisfy the requirements for federal subject matter jurisdiction on their own. Okay, so we can kind of draw up a basic example, right? This is kind of the fact pattern we're looking out for when we're thinking about supplemental jurisdiction. Let's say we have a plaintiff who is a citizen of Texas suing a defendant who is also a citizen of Texas in federal court. Okay, so off the top, right, if we have a plaintiff who's a citizen of Texas suing a defendant who is a citizen of Texas in federal court, for that federal court to have subject matter jurisdiction over the case, what do we need? Well, we're going to need an ingredient of federal law, right? Because diversity jurisdiction is off the table. So a state law claim, a claim that does not arise under federal law, is not going to be able to be heard by the federal court when we have non-diverse parties. So we know, as we start to look at this illustration, we need a federal law claim, right? The federal court is not going to be able to exercise diversity jurisdiction. So if a state law claim comes in, we know the federal court's not going to be able to hear that claim, right? We need the ingredients of federal law. So let's say we get that. Let's say the plaintiff brings a federal law claim that satisfies Section 1331 federal question jurisdiction. Okay, no problem. If the plaintiff, who's a citizen of Texas, is suing a defendant who is also a citizen of Texas in federal court, but the plaintiff brings a claim that arises under federal law, great. We know that the federal court has subject matter jurisdiction to hear and decide that case. But let's say the plaintiff doesn't just bring one claim. Let's say our plaintiff brings two claims against this defendant. Let's say the second claim is just a state law claim. It could be a breach of contract claim. It could be a tort claim, negligence, whatever, right? Our plaintiff brings an additional claim that's just state law. It does not arise under federal law. Well, independently, does the federal court have jurisdiction over that second claim? The answer is no. They don't have diversity jurisdiction over the claim. We know the plaintiff and defendant share citizenship in Texas, so the federal court cannot exercise diversity jurisdiction over that state law claim. And obviously, the federal court cannot exercise federal question jurisdiction over a state law claim that does not arise under federal law. So on its own, in a vacuum, the federal court cannot exercise subject matter jurisdiction over that state law claim. However, right, that state law claim is not in a vacuum. It's being brought with a federal law claim. So the deal here is, in this situation where the court has original jurisdiction over that federal claim, right? It has federal question jurisdiction, valid subject matter jurisdiction over the original claim. Supplemental jurisdiction allows the federal court here to exercise supplemental jurisdiction over the state law claim that it does not independently have subject matter jurisdiction over if that state law claim basically is sufficiently related to the original claim. And to make this determination, we have to basically follow 1367. Section 1367 lays out the requirements as to whether the court can exercise supplemental jurisdiction over an additional claim. But here, we just want to understand big picture what we're looking for. To summarize this, right, we need at least two claims. If we only have one claim, basically a single plaintiff suing a single defendant on one claim, supplemental jurisdiction cannot possibly be at issue. We need an additional claim, right? We need one claim that the federal court has valid subject matter jurisdiction over, usually through federal question or diversity jurisdiction. And then we need an additional claim that the federal court does not have an independent basis of subject matter jurisdiction for. So it does not have federal question or diversity over the additional claim. Then at that point, supplemental jurisdiction is at issue. The question will be, the issue is whether the federal court can exercise supplemental jurisdiction over the additional claim. What if, on this little diagram we have drawn up here, we have a plaintiff who's a citizen of Texas suing a defendant who's a citizen of Texas, but our plaintiff brings two different federal law claims that both satisfy federal question jurisdiction. Is supplemental jurisdiction at issue? The answer is no, right? If the court has an independent basis of jurisdiction over both claims, then we don't have to discuss supplemental jurisdiction, right? Both claims satisfy federal question jurisdiction. Therefore, the court can exercise jurisdiction over both claims. So in that case, supplemental jurisdiction is not at issue. So just because we see multiple claims in a fact pattern, that doesn't necessarily mean supplemental jurisdiction is at issue. If the court has an independent basis for jurisdiction, basically if each claim satisfies federal question or diversity on its own, we're not dealing with supplemental jurisdiction. Supplemental jurisdiction is only at issue when we have a situation like we have on this slide. Kind of as we have signified here with a green arrow and a red arrow. The green arrow means, hey, this claim, this green arrow claim, independently satisfies federal subject matter jurisdiction. The red arrow claim does not independently satisfy subject matter jurisdiction. And the question is, okay, because the court has valid subject matter jurisdiction over one claim, can it exercise supplemental jurisdiction over the additional claim that it does not have an independent basis of subject matter jurisdiction for? That is supplemental jurisdiction from an issue spotting perspective. Let's actually get into the analysis. Okay, so we have one claim that the court has jurisdiction over, and we have an additional claim the court does not have an independent basis of jurisdiction over. How do we determine whether that federal court can exercise supplemental jurisdiction over the claim? We go to section 1367, which provides a three-step inquiry. Step number one, under section 1367A, we need to determine whether the claim qualifies for supplemental jurisdiction. Step number 2, under 1367B, we have to determine whether the claim is disqualified for supplemental jurisdiction when the court's original jurisdiction is based solely on Section 1332 diversity jurisdiction. And finally, step number 3, under Section 1367C, we have to determine whether the court at its own discretion should decline to exercise supplemental jurisdiction. So step 3, even if we get past step 1 and step 2, the court doesn't necessarily have to exercise supplemental jurisdiction over the claim. There's some discretionary factors we consider as to whether the court should or should not, even if step 1 and 2 are satisfied. Okay, that's our 3-step inquiry from Section 1367. We can jump right into step number 1, basically qualifying for supplemental jurisdiction under Section 1367A. Okay, so absent the disqualifications and discretionary factors provided by Section 1367B and C, under Section 1367A, when a federal court has subject matter jurisdiction over one or more claims in an action, what we call the court's original jurisdiction, the court has supplemental jurisdiction over all other claims that are so related to claims in the action within such original jurisdiction that they form part of the same case or controversy under Article 3 of the United States Constitution. Okay, so basically, when we're trying to determine whether that additional claim qualifies for supplemental jurisdiction, the big question is, do these claims form part of the same case or controversy? Are they so related that the claims actually form part of the same case or controversy? If so, then that additional claim to the original claim qualifies for supplemental jurisdiction. So how do we make this determination? Well, we have the common nucleus of operative fact tests. We say here, 2 or more claims in an action are considered so related that they form part of the same case or controversy if the claims arise from a common nucleus of operative fact such that a plaintiff would ordinarily be expected to try them all in one judicial proceeding. So we're looking for a connection between the claims. We're looking for a relationship, a nexus, a connection, a common nucleus of operative fact between the original claim that the court has jurisdiction over and the additional claim that the court lacks an independent basis to have jurisdiction over. We need that connection such that a plaintiff would ordinarily be expected to try them all in one judicial proceeding. This idea kind of highlights the entire purpose of supplemental jurisdiction. As we work through these fact patterns, and we're about to jump into just some practice problems so we can see how this all plays out, I think it's important to recognize the reason we have supplemental jurisdiction is to promote judicial efficiency, right? If you think about the old idiom we have in the English language, killing 2 birds with 1 stone, it's kind of the whole purpose of supplemental jurisdiction, right? If we have 2 claims that are so related, they essentially form part of the same case or controversy, supplemental jurisdiction says no need to litigate these in separate lawsuits, right? We can just form them in one and knock both claims out at the same time. We're killing 2 birds with 1 stone. No need to bring a claim in state court and another claim in federal court. If the claims are so related, they really form part of the same case or controversy. If they arise out of that common nucleus of operative fact, let's just knock both of the claims out at once, right? Killing 2 birds with 1 stone. It's all about promoting judicial efficiency. And I think that will, if we think about supplemental jurisdiction through that legislative intent, I think a lot will make sense as we work through some of these practice problems. Okay, so we can start with our first one. All right, practice problem 1.0. Here, Pam works for a large company. One day, Pam's car is unintentionally hit in the company's parking lot. Since the damages were minor, Pam took no legal action. 5 years later, Pam is fired by the company on the basis of her age. Pam then files a lawsuit in federal court alleging age discrimination under federal law and negligence under state law for damages from the car collision. Both parties are citizens of Texas. Does the state law tort claim qualify for supplemental jurisdiction under Section 1367A? Okay, well, we can draw this up to see kind of what's going on, right? So we have a plaintiff who's a citizen of Texas suing a defendant who's a citizen of Texas on two claims. We have a federal claim that arises under federal law, right? Probably the ADEA, the Age Discrimination in Employment Act. This is federal law. So we know the age discrimination claim arises under federal law. That satisfies Section 1331 federal question jurisdiction. But Pam is also bringing this state law tort claim that arises out of the car accident 5 years earlier, right? And we know because the plaintiff and defendant are both citizens of Texas, well, this federal court cannot exercise diversity jurisdiction over the state law tort claim. The parties are not diverse. And we know that the federal court cannot exercise federal question jurisdiction over the state law tort claim because the state law tort claim does not arise under federal law. So the only way that the federal court can hear and decide this state law tort claim is through supplemental jurisdiction. Because the federal court has valid subject matter jurisdiction over the federal law claim, the age discrimination claim, basically, if that state law tort claim is sufficiently related, right, under Section 1367, then we know that the federal court could potentially exercise supplemental jurisdiction over the state law claim. But we start with step one. Does it even qualify for supplemental jurisdiction? Are the claims, is the federal law claim so related to the state law claim that they form part of the same case or controversy? How do we make that determination? Well, we have to think, does the state law tort claim arise out of a common nucleus of operative fact as the federal law claim, the age discrimination claim? And so we kind of have the answer here on the next slide. We say here, there is no evidence that the car collision is so related to Pam's termination of employment that they form part of the same case or controversy. Although the collision happened at Pam's place of work, the collision was unintentional and occurred 5 years prior to her termination of employment. Thus, the claims do not arise out of a common nucleus of operative fact, and Pam would not be reasonably expected to try both claims in a single proceeding. So in other words, our state law tort claim does not qualify for supplemental jurisdiction. In this case, Pam would have to file the federal law claim. She could file the federal law claim in federal court. That's fine because it satisfies federal question jurisdiction. But the court cannot exercise supplemental jurisdiction over the state law claim because it's not sufficiently related to the federal law claim. So if Pam wanted to bring that action, she'd have to do so separately in state court, right? She can't bring both claims at the same time in federal court. So she could file one in federal court, and then she could file the state law claim in state court if she wanted to pursue both claims. But the federal court is not going to be able to exercise supplemental jurisdiction over the state law claim. And it's because they're not really related. Right, if we think about these claims, they don't arise out of a common nucleus of operative fact. They both kind of live in their own universe. We have a car accident in a parking lot, and then 5 years later, Pam is wrongfully terminated. Although both technically, involve her workplace, right? The parking lot is at her office. That is not enough of a connection here. Think about the idea of promoting judicial efficiency. What we're really looking for is like evidence to overlap. Like if you're going to litigate that car collision case and you're saying, look, the defendant here, my company I work for, is somehow negligent. Maybe you're arguing that the parking lot is constructed in such a way that it encourages car collisions. It's just not a properly constructed parking lot. Well, maybe you need to bring in like evidence of the blueprint, like how was this built? Maybe you need pictures of the parking lot. Maybe you need witnesses or cameras that were recording what was happening in the parking lot. Maybe you need statistics of accidents in the parking lot. None of this has anything to do with her being discriminated against on the basis of her age and terminated 5 years later. The evidence you would need for that claim is like in its own different universe. You would need like, okay, how was she treated in the workplace? What evidence is there of this company's history of employees of a certain age? That would all deal with her treatment in the workplace and the actions that gave rise to her being terminated. So there's just like no nexus. There's no connection between the car accident 5 years earlier in the parking lot and the age discrimination claim. So for that reason, the state law tort claim is not going to qualify for supplemental jurisdiction. We can't really kill two birds with one stone here. These claims don't have anything to do with one another. Therefore, Pam really wouldn't reasonably be expected to try both claims in a single proceeding. Okay, so hopefully we can kind of see that, right? Their claims just are not related enough. So we can go to a different fact pattern, kind of change it up and see if we can make the claims a little bit more related. So let's go to practice problem 2.0. Here, Pam, a 60-year-old woman, was employed by Doug. Doug regularly criticized her work and made derogatory comments about her age publicly. Eventually, Doug fired Pam in front of her colleagues, falsely claiming that she had stolen supplies. Pam filed a lawsuit in federal court, again alleging age discrimination under federal law and defamation under state law on the basis of the false accusation. Both parties are citizens of Texas. Does the state law defamation claim qualify for supplemental jurisdiction under Section 1367A? We can draw this up again, right? Let's just kind of map out the anatomy of the lawsuit. So again, we have a plaintiff, Pam, who's a citizen of Texas, suing Doug, the defendant, who is also a citizen of Texas. So we know diversity jurisdiction is off the table. All right, she's bringing a federal law claim that satisfies federal question jurisdiction, and she's bringing a state law claim that does not satisfy either federal question jurisdiction or diversity jurisdiction. So obviously the question here is, can the federal court exercise supplemental jurisdiction over that state law defamation claim? They have federal question jurisdiction over the age discrimination claim, but the question is, can they exercise supplemental jurisdiction over the state law defamation claim, right? Because they don't have federal question jurisdiction over a state law claim, and they don't have diversity jurisdiction where both parties are citizens of Texas. So the only way a federal court can hear that state law defamation claim is going to be through supplemental jurisdiction. So we start with step 1, 1367A. Basically, are the claims, is the federal law claim so related to the state law defamation claim that the claims form part of the same case or controversy? How do we make that determination? We apply the common nucleus of operative fact test. Do the claims arise out of a common nucleus of operative fact? Well, we have the answer here. Right here, both claims relate to how Pam was treated in the workplace. Both claims concern the alleged reasons for Pam's termination of employment. The false accusation, remember her stealing supplies, which is the basis of the defamation claim, explicitly related to Pam's characteristics as an employee and was made to justify Doug's decision to fire her. Thus, the claims arise out of a common nucleus of operative fact, and Pam would be reasonably expected to try both claims in a single proceeding. So here, we kind of can knock two birds right with one stone. These claims are very related. They're interwoven. If we think about, how you would litigate both of these claims, if we have a federal law claim based on age discrimination and the state law defamation claim, well, the age discrimination claim is based on basically why Pam was fired. Obviously, Doug's going to say she stole supplies, which is the defamation, right? Because Pam is saying, I didn't steal any supplies. That's a lie, and that harms my character. You've defamed me by saying that. So you really can't have the federal law claim without bringing in the evidence of the defamatory statements. The claims are so connected here, right, that Pam would be reasonably expected to try them both in one proceeding, right? You're going to have lots of the same witnesses, lots of the same evidence. It all overlaps, right? They all arise out of a common nucleus of operative fact, which basically all of it deals with how Pam was treated in the workplace, right? And that's why Pam could probably knock, or the court would say, she would be reasonably expected to try both of these in one proceeding. We can knock both out with one stone. There's enough overlap. Both these claims arise out of a common nucleus of operative fact. So hopefully we can kind of compare those two problems in our head, problem 1.0 and 2.0, and kind of see the difference. With our first practice problem, we have a car accident that's pretty much unrelated to an age discrimination claim that happens 5 years later. And in the second practice problem, we see this correlation, this connection, this nexus between the two claims. We see that the defamatory statements, the false accusation, directly relates to the age discrimination claim. It goes to the reason Pam was actually fired. Was she fired on the basis of her age or because she stole supplies? Well, the fact that she didn't steal supplies, and that makes this basically publication of a false statement that harms her reputation, right? It's all interwoven. You can't basically have like one litigation without bringing in evidence of the other. Okay, so for that reason, we'd say these arise out of a common nucleus of operative fact. The court, well, at least the state law defamation claim, therefore, would qualify for supplemental jurisdiction under Section 1367A. We're not ready to say, remember, whether the court can exercise supplemental jurisdiction over the claim. Remember, we have two other steps. We have to go to step 2 and step 3 in our analysis. But we are ready to say, okay, that state law defamation claim does qualify for supplemental jurisdiction under step number 1. Okay, so before we go to step number 2, 1367B, we do need to think about the same transaction or occurrence test, right? And basically how this relates to the common nucleus of operative fact test. So most courts have found that claims which satisfy the same transaction or occurrence test under Rule 13 or Rule 20 of the Federal Rules of Civil Procedure also qualify for supplemental jurisdiction under Section 1367A. Another way to say this is, if multiple claims arise out of the same transaction or occurrence, the claims are also considered to arise out of a common nucleus of operative fact. Important to recognize here that the reverse is not necessarily true. Some courts have found that the common nucleus of operative fact test is broader than the same transaction or occurrence test. Okay, so what do we mean here? Why are we bringing up the same transaction or occurrence test? Basically, under Rule 13 and Rule 20, the drafters of the Federal Rules of Civil Procedure basically came up with the same transaction or occurrence test. If you read Rule 13 or Rule 20 from the Federal Rules, you're going to see this language about same transactions and occurrences. And the idea there is, at least with like Rule 13, this is how a court would determine whether a counterclaim is compulsory or permissive, right? If the counterclaim arises out of the same transaction or occurrence as the original claim, the court says it's compulsory, right? This is all Rule 13. Rule 20 deals with joinder of parties and basically whether it's proper to join multiple plaintiffs or multiple defendants. And one of the requirements there is that the claims being asserted by those parties arise out of the same transaction or occurrence. So what you see a lot of times is basically in a separate analysis, a court is applying the same transaction or occurrence test, which is very similar to the common nucleus of operative fact test. And basically, if a court says, hey, the same transaction or occurrence test is satisfied for this claim, basically this claim, take like a counterclaim, for example. Basically, this counterclaim arises out of the same transaction or occurrence as the original claim, so that makes the counterclaim compulsory. Well, really, at the same time, you're saying that claim arises out of a common nucleus of operative fact. So not only is that counterclaim compulsory under Rule 13, If we apply supplemental jurisdiction to that counterclaim, we know it now qualifies for supplemental jurisdiction under Section 1367A because basically the common nucleus of operative fact test is broader than the same transaction or occurrence test. Okay, so we'll break this down with some examples. I know that's confusing. First, though, we can just visualize the two tests. We have a little chart here, right? If we think about the common nucleus of operative fact test, we think of it as broader than the same transaction or occurrence test. So we see here like the same transaction or occurrence test is kind of fully encapsulated. It's a concentric rectangle inside the common nucleus of operative fact rectangle, right? Basically, if we were to pinpoint claims on this chart, any claim that falls in that same transaction or occurrence test box also, by definition, falls in the common nucleus of operative fact box. So again, it's possible procedurally, and you might do this in your analysis, right? And we're going to break down Rule 13 and Rule 20 in a lot of detail when we get to basically joinder of parties and claims. We're going to talk a lot about Rule 13, Rule 20, and how the same transaction or occurrence test is satisfied and when we really apply it. But the point is, if the same transaction or occurrence test is applied by a court, you don't necessarily then have to reapply the common nucleus of operative fact test. Like if a court says, hey, this counterclaim arises out of the same transaction or occurrence as this original claim, therefore the counterclaim is compulsory, then the court can also say, therefore, we can also exercise supplemental jurisdiction over this counterclaim under 1367A, because if a counterclaim arises out of the same transaction or occurrence as the original claim, it also arises out of a common nucleus of operative fact as the original claim. So let's just go through a practice problem and see how this plays out, okay? Here, practice problem 3.0. Let's say Pam contracts Doug to write a book for $10,000. However, Pam never pays Doug. Upset by this, Doug posts excerpts from the book on his blog without Pam's consent. Pam then files a lawsuit in federal courts alleging copyright infringement under federal law on the basis that the book is her intellectual property pursuant to their contract. Doug countersues for breach of contract under state law because he was never paid. Pam and Doug are both citizens of Texas. Does Doug's state law counterclaim qualify for supplemental jurisdiction under 1367A? Let's draw it up. Okay, so Pam and Doug are both citizens of Texas. So Section 1332, diversity jurisdiction, is off the table. So Pam files this federal copyright infringement claim. We know copyright law, copyright cases are exclusively allocated to federal courts. So the federal court here is going to have federal subject matter jurisdiction over the copyright claim. However, Doug countersues, right? He files a counterclaim, just pure state law breach of contract. Well, let's think about whether the federal court has independent jurisdiction over that state law breach of contract case. Can the federal court exercise federal question jurisdiction over a state law breach of contract claim that does not arise under federal law? Answer is no. Can the federal court exercise diversity jurisdiction over the state law breach of contract claim? Answer is no. Both parties are a citizen of Texas. Okay, so the only way that the federal court can hear that counterclaim is through supplemental jurisdiction because they have jurisdiction over the copyright case, right? We know federal courts can hear copyright cases. It's federal law. Federal law exclusively allocates jurisdiction over copyright cases to federal courts. Okay, so the federal court has subject matter jurisdiction over the copyright infringement claim. Can they exercise supplemental jurisdiction over the state law breach of contract counterclaim? Well, the court at some point in its analysis might apply the same transaction or occurrence tests to that state law breach of contract counterclaim because counterclaims are governed by Rule 13. And Rule 13 says, look, a counterclaim is compulsory if the counterclaim arises out of the same transaction or occurrence as the federal copyright infringement claim, as the original claim. Okay, so if the court says, basically, we can go to the answer. Here, Doug's counterclaim arises out of the same transaction or occurrence as Pam's copyright claim, as both claims arise out of the same contract. So by the way, the same transaction or occurrence tests, we're going to break down in a future lesson, like what the outer limits of the same transaction or occurrence tests are, like defining that test in full detail. But for now, we can accept if two claims arise out of the same legal document, the same transaction, basically the execution of a contract, one party's basically saying, hey, you breached this clause of the contract, and the other party's saying you breached this different clause in the same contract. We say those claims arise out of the same transaction. They come from the same contract. With occurrences, think like in tort law. If we have two parties injured in one car accident, right? Well, we say both of their claims are going to arise from the same occurrence, the same car accident, right? The parties are injured in the same car accident, the same occurrence. If they both file a claim, their claims arise out of the same transaction or occurrence. Okay, so that's like the basic understanding of same transaction or occurrence. We'll break it down in more detail in a future lesson. The point here is Doug's counterclaim very clearly arises out of the same transaction or occurrence as Pam's copyright claim because both claims come from the same contract. Pam is saying the contract defines the book as my intellectual property. You've breached basically this clause of the contract, which has resulted in this copyright infringement as you've gone now and published my intellectual property without my permission. And Doug's saying you never paid me under the terms of the contract. So really, these claims arise out of the same contract, the same transaction, the interpretation of this contract. So here the court would say Doug's counterclaim is compulsory under Rule 13. And remember, most courts have found that claims which satisfy the same transaction or occurrence test under Rule 13 or Rule 20 also qualify for supplemental jurisdiction under Section 1367A. As such, Doug's counterclaim would likely qualify for supplemental jurisdiction. If we put this on our chart, right, if we pinpoint Doug's counterclaim in that same transaction or occurrence box, we can see it's also within the common nucleus of operative fact box. That's how kind of simultaneously the counterclaim can qualify as compulsory under Rule 13 and can also qualify for supplemental jurisdiction under Section 1367A contemporaneously. Okay, so this is how you see the same transaction or occurrence test kind of interwoven in the supplemental jurisdiction analysis. The important takeaway, though, that I would think about here, if we're not dealing with, say you have this same practice problem 3.0, and you don't have to determine whether the counterclaim is compulsory or permissive, right? You're not really applying Rule 13 to this counterclaim. Say you get a fact pattern that only asks you whether the court can exercise supplemental jurisdiction over the counterclaim. You could just apply the common nucleus of operative fact test directly to the counterclaim and come to the same conclusion, right? You could do exactly what we did in practice problem 1 and 2. You could apply that same analysis to the counterclaim. You could also apply the Rule 13 same transaction or occurrence test and then say, look, most courts find that if a counterclaim arises out of the same transaction or occurrence as the original claim, then that means the counterclaim arises out of a common nucleus of operative fact as the original claim. So it qualifies for supplemental jurisdiction. Both ways are going to get you to the same conclusion, right? And different courts analyze it differently. But this is how you see the same transaction or occurrence test kind of interwoven in the supplemental jurisdiction analysis. So I wanted to at least cover this so we know, because sometimes you're going to see the same transaction or occurrence test used in the supplemental jurisdiction analysis. That's usually what's happening. When we see a court do this in real life, it's because they've already established under Rule 13 or Rule 20 that two claims arise out of the same transaction or occurrence. So then they basically just use like the transitive property from math, not to bring in math concepts, but basically if they say, hey, this arises out of the same transaction or occurrence, it also arises out of a common nucleus of operative fact, rather than like redoing the whole analysis. Okay, so that's how we see it interwoven. Last point I would make here is it is possible, according to some courts, that a counterclaim, for example, you could have a permissive counterclaim, a counterclaim that does not arise out of the same transaction or occurrence as the original claim. So it's permissive. But that claim, even though it does not arise out of the same transaction or occurrence as the original claim, it could arise, according to some courts, out of a common nucleus of operative fact as the original claim. So remember, the reverse is not necessarily true. It's possible if we drew this on our little chart here, we could have a counterclaim that falls outside the same transaction or occurrence test box that's still within the common nucleus of operative fact box, okay? So just because something a counterclaim does not arise out of the same transaction or occurrence, it does, as another claim, as the original claim, it does not necessarily mean that counterclaim does not qualify for supplemental jurisdiction. Some courts say the common nucleus of operative fact test is broader than the same transaction or occurrence test. Okay, so we want to keep that in mind, kind of as our final point here on the same transaction or occurrence test. Okay, but otherwise, my recommendation here would be if you're being asked explicitly on a law school exam or the bar exam, basically whether a court can exercise supplemental jurisdiction over a counterclaim, a cross-claim, something that also falls within like Rule 13, I would just apply the common nucleus of operative fact test exactly like we did in practice problem 1 and practice problem 2, right? You don't have to bring up the same transaction or occurrence test to determine whether a claim qualifies for supplemental jurisdiction. It just so happens that sometimes earlier in your analysis, you may have used the same transaction or occurrence test for some other purpose to come to a conclusion. Under Rule 13, it would usually be to determine whether a counterclaim is compulsory or permissive. Under Rule 20, it would be whether joinder of parties is proper. Okay, and so maybe if you're doing some sort of Rule 13 or Rule 20 analysis, you already applied the same transaction or occurrence test. If you've already applied the same transaction or occurrence test and found that it's satisfied, well, then you can say, look, most courts will say that also means that this claim arises out of a common nucleus of operative fact as the original claim, and therefore it also qualifies for supplemental jurisdiction. But if you haven't already applied the same transaction or occurrence test and you're just being asked whether a claim qualifies for supplemental jurisdiction, I would just apply directly the common nucleus of operative fact test, exactly like we did in practice problem 1 and 2. Okay, but that's the same transaction or occurrence test as it relates to supplemental jurisdiction. Remember, we're going to break down same transaction or occurrence, counterclaims, cross-claims, Rule 20 joinder, Rule 13. We're going to break all of those concepts down in way more detail in future lessons. The point here is to understand sometimes you see the same transaction or occurrence test interwoven in a supplemental jurisdiction analysis. I just wanted to explain how that happens, kind of what you're looking for there, because sometimes you're going to see that taught in law school, right? You're going to see the same transaction or occurrence test taught when supplemental jurisdiction is being discussed. That's kind of how it fits within the analysis. Okay, but fundamentally, that is step 1, right? If we're thinking about our 3-step inquiry for supplemental jurisdiction under 28 U.S. Code section 1367, right? Remember, step 1, we're determining under 1367A whether the claim qualifies for supplemental jurisdiction, right? We have an original claim the court has an independent basis for subject matter jurisdiction over, and we have an additional claim the court does not have an independent basis for subject matter jurisdiction over. And the question is, does that additional claim qualify for supplemental jurisdiction? And it's really about how related it is, right? Is it sufficiently related to the original claim. And to make that determination, we apply the common nucleus of operative fact test. That is step number 1. Step number 2, under 1367B, we have to determine whether the claim is disqualified for supplemental jurisdiction when the court's original jurisdiction is based solely on Section 1332 diversity jurisdiction. Okay, so I find when we move to step number 2, and we're thinking about 1367B, basically as a disqualifier, okay, for supplemental jurisdiction, I find it's best to start with the legislative intent. What is the purpose of Section 1367B? If we understand the purpose of Section 1367B, I think it becomes much easier to apply. So here we say the purpose of Section 1367B is to prevent plaintiffs from being able to evade the jurisdictional requirement of 28 U.S. Code Section 1332 diversity jurisdiction by naming initially only those defendants whose joinder satisfies diversity jurisdiction's requirements, and later adding claims not within original federal jurisdiction against other defendants who have intervened or been joined on a supplemental basis. Okay, so let's break this down. Like, what does this look like if we're trying to understand the purpose of Section 1367B? So let's say, okay, for a second, let's pretend that Section 1367B does not exist. And let's say I'm a really crafty plaintiff. I know the rules of civil procedure really well. However, 1367B does not exist. And let's say that I really want to sue a non-diverse party in federal court on a state law claim, right? Which we know generally you can't do, right? How can I sue a non-diverse party on a state law claim in federal court? Federal question jurisdiction is not satisfied. Diversity jurisdiction is not satisfied. Well, maybe I can attempt to use supplemental jurisdiction to get that claim in. I really want to smuggle that claim into federal court. I could do this. If 1367B did not exist, I could do the following. So let's actually, map this out with a real fact pattern to make it even easier to see. So let's say I am injured in a car accident. Let's say I'm hit by a truck driver. And this truck driver is employed by a really large trucking company. And so let's say I have millions of dollars in damages based on this car accident. Well, I know that, most Americans don't have millions of dollars lying around. This truck driver likely does not have millions of dollars for me to recover. So really, I want to sue the truck driver's company, his employer. Maybe they have millions of dollars and I can get it from, the company he works for. But let's say there's a problem. The truck driver's company and I share citizenship. So let's say this big company that has all the money is a citizen of Texas and I'm also a citizen of Texas. And let's say my claim is purely state law. So I can't sue that big company that has all the money in federal court. And let's say for whatever reason, I think federal court is going to be a really favorable forum. And this could be for a multitude of reasons, but doesn't matter. For whatever reason, I really want to bring this in federal court. I think it's going to be very advantageous as a plaintiff if I can get this case into federal court. Remember though, I really want to sue the big company that's got a lot of money, but I can't because we share citizenship and my claim is a state law claim. So I can't get them into federal court with federal question or diversity. But let's say I'm clever as a plaintiff and I recognize that the truck driver is actually a citizen of Florida. So what I could do is I could sue the citizen of Florida in federal court, right? I could take the truck driver and I could sue him for negligence. I could say, hey, you rear-ended me and I'm going to sue you for $100,000 in federal court. Well, I'm a citizen of Texas. The truck driver defendant is a citizen of Florida. So we're diverse and I'm suing him for $100,000. So the amount in controversy exceeds $75,000. So I can go to federal court with this lawsuit and the federal court would look at it and they say, okay, we can hear this, right? This is diversity jurisdiction. We have a plaintiff from Texas suing a defendant from Florida. So we have complete diversity and the amount in controversy exceeds $75,000. So the federal court's going to say, great, we can hear this case. And so let's say we start the litigation process. And at some point I say, oh, you know what? I forgot to add this other defendant to the claim, right? Or to the lawsuit. So using some rule of civil procedure, it doesn't matter. I guess here it could be well, it depends, right? If, say, to make this easy, right? Say at some point the truck driver says, you know what? Actually, I have, this truck driving company that's really responsible. Say that the truck had like faulty brakes or something on it, right? And this was negligence on part of the company that's got a lot of money. So let's say under Rule 14, Impleader, the defendant brings in the truck driving company, okay? And now I say, oh, wait, you know what? I forgot this thing in my complaint. I forgot to mention that I have millions of dollars of damages against the big company with a lot of money. I'm going to amend my complaint and I'm going to file a claim for millions of dollars against the truck driving company now that they've been impleaded into the lawsuit. So essentially, right, I've smuggled the claim I really wanted into federal court, right? I used the truck driver basically as a patsy, right, to establish jurisdiction in federal court because I have diversity with the truck driver. So I bring him into court, I establish federal subject matter jurisdiction, and I know he's going to bring in the defendant I really want brought in that's got millions of dollars. I wait for that defendant to be brought in, and then I amend my complaint, file a claim for millions of dollars, and now the court can exercise supplemental jurisdiction over this defendant that's been added in, right? The person I wanted. And I've basically completely defeated the purpose of Section 1332 diversity jurisdiction. I've circumnavigated the rules and found a way to bring a non-diverse party into federal court and sue him purely on a state law claim, right? So I've ultimately gotten what I've wanted. I have a non-diverse party that I'm suing on a state law claim in federal court. I basically just used supplemental jurisdiction as my gateway to achieve this. This fact pattern is exactly what Section 1367B is preventing, right? It's preventing people, plaintiffs, from smuggling in, and this is the word courts use, right? Smuggling in claims to federal court, right? That really defy the purpose of Section 1332 diversity jurisdiction. Okay. So this is the fact pattern we're looking out for, right? We're looking out for a situation where the litigation starts kind of with, a plaintiff suing one defendant on the basis of diversity jurisdiction. That exists, and then something happens and the complaint is amended, and now there's like an additional claim getting filed that destroys diversity. But hey, the court can still exercise supplemental jurisdiction if we don't have 1367B. This is what 1367B is preventing. Like, that's the fact pattern we're watching out for. So we can actually get into 1367B as a disqualifier, like the language of the statute, right? So here under 1367B, in an action where the federal court's original jurisdiction is based solely on Section 1332 diversity jurisdiction, the court does not have supplemental jurisdiction over the following claims. When exercising supplemental jurisdiction over such claims would be inconsistent with Section 1332 diversity jurisdiction. Claims by plaintiffs against persons made parties under Rules 14, 19, 20, or 24, persons proposed to be joined as plaintiffs under Rule 19, and persons seeking to intervene as plaintiffs under Rule 24. So, obviously, to fully understand Section 1367B, we have to kind of understand these joinder rules, Rules 14, 19, 20, and 24. I can give a very quick summary of these, but important to recognize we're going to discuss all of these rules in a lot more detail in future lessons. When we get into our discussion of counterclaims, cross-claims, and joinder of claims and parties, we're going to get into Rules 14, 19, 20, 24 in way more detail. But just so we have a baseline and we can kind of understand here, these rules, 14, 19, 20, and 24, all deal with joining plaintiffs and defendants in a lawsuit. Rule 14 would be Impleader. So basically, if you're sued as a defendant and you know there's a third party out there that's also liable or responsible for the damages you've been sued for, you can implead that third party defendant. Maybe it's like an employer, right? You've been sued as an employee and you know the employer is vicariously liable for the harm. You could implead that employer into the lawsuit. This would be common in indemnification cases. Maybe you have a contractual relationship with a third party who's agreed to indemnify you. You might seek indemnification against that party by impleading them under Rule 14 into the lawsuit. Rule 19 is compulsory joinder. Basically, sometimes a party can be so indispensable to the adjudication of the lawsuit that justice requires basically mandatorily joining this party into the lawsuit. The court can actually do this on its own, sua sponte. A court can say, hey, plaintiff, you left out a party here. And by the way, it doesn't have to be a defendant being joined, but that's classically what you see when you see Rule 19. Basically, the plaintiff has left out a defendant and the court says, hey, we can't really adjudicate this lawsuit unless this party who's absent is brought in, right? They're indispensable to the lawsuit. This would be compulsory joinder. Basically, that party is forced to join the lawsuit. That'd be Rule 19, compulsory joinder. Rule 20 is permissive joinder. Basically, plaintiffs have the option to join together with other plaintiffs or join multiple defendants in the lawsuit permissively at their discretion if certain requirements are met, usually that the claims being asserted by all those parties arise out of the same transaction or occurrence, and there's a question of law or fact common to all those claims, right? This would be permissive joinder under Rule 20. Rule 24 is intervention. This would be like a third party, basically one way or another, hears about the lawsuit and is like, hey, you can't litigate this without me present. The outcome of this lawsuit affects my rights and liabilities, and I'm not being adequately represented. So I have to intervene in the lawsuit. That would be Rule 24. Okay, the basics there. And by the way, a lot of that gets kind of complex. We'll discuss all of those in way more detail in future lessons. The point is just understanding the different ways kind of parties can be joined to a lawsuit for supplemental jurisdiction purposes. And what we're thinking about here with 1367B is when the court's original jurisdiction is based on diversity jurisdiction, if some party is being joined by one of these rules, 14, 19, 20, or 24, into the lawsuit, and that party destroys diversity between the parties, and then our plaintiff files a claim against that party who's now destroyed diversity, 1367B basically disqualifies the federal court from exercising supplemental jurisdiction over that claim because it circumnavigates the entire purpose of Section 1332 diversity jurisdiction. We can go to practice problem 4.0, see this in an actual, fact pattern. Here, Doug, a citizen of state A, rented a car from auto company, a citizen of state B. While driving the rental car, Doug applied the brakes, which failed, causing Doug to rear-end Pam. Pam is a citizen of State B. Pam brought a state law negligence claim against Doug in federal court, seeking $100,000 in damages. Doug filed a third-party complaint seeking indemnification against Auto Company for the brake failure. Pam then amended her complaint to assert a state law products liability claim against Auto Company. Can the federal court exercise supplemental jurisdiction over Pam's product liability claim against Auto Company? This is basically exactly what we just discussed. Hopefully we all see the answer to that is no under 1367B, but we can map it up and break this down. Right, so we have Pam, a citizen of State B, bringing a state law tort claim for $100,000 against our first defendant, who's a citizen of State A, who is Doug, right? So we have Pam, a citizen of State B, suing Doug, who's a citizen of State A, for $100,000. So boom, right there, we know the federal court has subject matter jurisdiction under diversity jurisdiction over that claim. No problem, okay? Pam, citizen of State B, suing Doug, citizen of State A. Complete diversity is satisfied. Amount in controversy exceeds $75,000. Federal court can exercise subject matter jurisdiction over that claim. No problem. However, what happens? Doug impleads Auto Company into the lawsuit. Doug, under Rule 14 Impleader, impleads Auto Company into the lawsuit. So Pam then amends her complaint and files this products liability claim, which is pure state law, against Auto Company. And notice, Auto Company destroys complete diversity. Pam is a citizen of State B, and Auto Company is a citizen of State B. So the federal court would not have an independent basis for jurisdiction, right? The state law products liability claim does not satisfy federal question jurisdiction, and because Pam and Auto Company are both citizens of State B, they don't have diversity jurisdiction over the claim. So the only way that the federal court can hear that state law products liability claim is through supplemental jurisdiction. And notably, right, these claims do arise out of a common nucleus of operative fact. 1367A is satisfied, right? When we think about the products liability claim, that brake failure arises out of the same occurrence, the same car accident that the state law tort claim against Doug is based on. So obviously a car accident where Doug rear ends Pam and is saying, hey, look, my brakes failed. That's what caused the car accident. Both claims, the brake failure defective product claim and the car accident claim, arise out of a common nucleus of operative fact. So the court, that claim would qualify for supplemental jurisdiction under 1367A, but we know there's a problem under 1367B. Right, under 1367B, that claim would be disqualified, right? Here, since the court's original jurisdiction is based solely on diversity jurisdiction, and Pam's product liability claim against Auto Company is a claim by a plaintiff against a person made a party under Rule 14, the court cannot exercise supplemental jurisdiction over the product's liability claim. Basically, that 1367B disqualifier is triggered in this fact pattern. Even though the claims arise out of a common nucleus of operative fact, again, because the court's original jurisdiction is based solely on diversity jurisdiction, and basically the product's liability claim against Auto Company is a claim by a plaintiff against a person made a party under Rule 14 Impleader, right? We know the court cannot exercise supplemental jurisdiction over the product's liability claim. That is just prohibited by 1367B. Okay, so that's 1367B. The important thing to recognize with 1367B is it's only triggered when the court's original jurisdiction is based on diversity jurisdiction. Remember the first problems we did, practice problem 1.0, 2.0, 3.0, all of those claims, the court's original jurisdiction was based on federal question jurisdiction. If that's the case, if the court's original jurisdiction is based on federal question jurisdiction, we just skip 1367B. It is not at issue. 1367B as a potential disqualifier only becomes an issue when the court's original jurisdiction is based on diversity jurisdiction. And what we're really looking out for there is that situation where the court's original jurisdiction is based on diversity, and then through some joinder situation, a party comes in that destroys diversity, and now, the plaintiff wants to file a claim against that person that's now destroyed diversity. Okay, that's the situation that 1367B is disqualifying. So it's critical that the court's original jurisdiction is based on diversity. If it's based on federal question, we basically skip step 2. We don't even think about 1367B if the federal court's original jurisdiction is based on federal question jurisdiction. This takes us to our final step, step number 3. Remember, under 28 U.S. Code, section 1367, we have this 3-step inquiry. We've discussed step 1 and step 2. Our final step, number 3, under 1367C, we have to determine whether the court at its own discretion should decline to exercise supplemental jurisdiction. This is pretty straightforward. We just get some discretionary factors from 1367C that we apply as our final step. And we basically say a federal court at its own discretion may decline to exercise supplemental jurisdiction over a claim if any of these factors are met. The claim raises a novel or complex issue of state law. The claim substantially predominates over the claim or claims over which the court has original jurisdiction. The court has dismissed all claims over which it has original jurisdiction, or in exceptional circumstances, there are other compelling reasons for declining jurisdiction. So we can kind of quickly talk about each of these factors, though, it's pretty intuitive. Okay, so if we're thinking about a situation where the federal court has valid jurisdiction over one claim, and then there's an additional claim the court does not have jurisdiction over independently. Let's say that the original claim for purposes of this illustration is based on federal law. So we have a federal law claim and a state law claim between parties who are citizens of the same state, right? So diversity jurisdiction's just off the table, and we have a federal court that has federal question over one claim, and they're trying to decide whether they should exercise supplemental jurisdiction over a state law claim. Okay, well, even if A and B are satisfied, we know in that analysis, 1367B, step 2, isn't even triggered because the court's original jurisdiction is based on federal question jurisdiction. So we do have, though, 2 claims that arise out of a common nucleus of operative fact. We have a federal law claim and a state law claim that arise out of a common nucleus of operative fact. We're skipping step number 2 and we're jumping to step number 3. Well, we would ask very quickly whether any of these factors raise an issue, right? Does that state law claim basically raise a novel or complex issue of state law? Sometimes the court might say, hey, look, we have the authority, right, to exercise supplemental jurisdiction of the state law claim, but this state law claim is unusual. It raises novel issues that this state has not decided, right? Think of like a Paul's graph situation, some wild fact pattern where we have a lot of things going on. There's a train accident and there's fireworks that explode and it sends a shockwave and it hits this person down the tracks, and we have like causation issues, duty issues. We have all these like novel issues that have not been decided. Maybe like a meteorite falls from the sky and it hits something, and this causes something to happen and something else to happen. And then the doctor at the hospital is like negligent and makes the injury worse. And so there could be all these like facts and questions of law that this state has not adjudicated. They don't have precedent set for. And the federal court might say, hey, look, even though this arises out of a common nucleus of operative fact as the federal law claim, we think the state court should adjudicate this matter because the issues here are complex and novel, and this state hasn't decided these issues. They need to set this precedent, basically. So we're going to let the state hear it. We're going to decline to exercise supplemental jurisdiction over the claim. That'd be your first factor. The second one would just be where basically that state law claim substantially predominates over the federal law claim. So this would be a situation where, and typically, a lot of times what you see here is like there's one federal law claim and then like a bunch of state law claims, and all the state law claims really predominate over the federal law claim. It could be in terms of damages, in terms of the facts, in terms of the litigation process. For whatever reason, those state law claims really are just substantially more integral to the lawsuit than the federal law claim is. And there the court might say, hey, look, these claims, the state law claim arises from a common nucleus of operative fact as a federal law claim. We have the authority to exercise supplemental jurisdiction over it, but really these state law claims just predominate so substantially over the federal claim, we think the state court should hear it. We're going to decline to exercise jurisdiction over the state law claims. Another common way you see a court decline to exercise supplemental jurisdiction, and I might say this is one of the most common ways when you see 1367 triggered and a federal court actually declines to exercise supplemental jurisdiction. I've seen a lot of cases where you actually have this third factor, where basically the federal court has dismissed all the claims over which it had original jurisdiction. So in that case, imagine very simply, you have a federal claim and a state claim. So the federal law claim establishes the subject matter jurisdiction of the federal court, and then the federal court's deciding, okay, we're going to exercise supplemental jurisdiction of the state law claim. But before they can make the determination as to whether the state law claim, they should exercise supplemental jurisdiction of the state law claim, the federal claim is dismissed for whatever reason. Maybe the plaintiff just drops it. Maybe it's dismissed on some other grounds. Who cares? But now you just have a state law claim, right, between non-diverse parties in federal court. At that point, right, the federal court would likely dismiss the case, right? They'd say, look, the court, we as the federal court have dismissed all the claims over which we had original jurisdiction, so we're not going to exercise supplemental jurisdiction over the additional claims where the claims we had original jurisdiction over have been dismissed. And then finally, you have this exceptional circumstances where, there could be other compelling reasons for declining jurisdiction. From the case law that I've read, typically, this is just a combination of the first three factors where you see a court say, look, this is exceptional because there's novel issues being raised. The state law claims substantially predominate over the federal law claims, and, certain claims have been dismissed. Usually it's some combination, and they say for this reason, it's exceptional, right? This is an exceptional case. There's compelling reasons to decline jurisdiction. Okay, but any reason that's exceptional or compelling, right, could be basically a catch-all under this fourth factor where the federal court could decline to exercise supplemental jurisdiction over a claim that satisfies basically 1367A and B. Okay, those are your discretionary factors. That's always your third step. Generally, from my experience on law school exams and the bar exam, it's not common you would see a federal court decline to exercise supplemental jurisdiction, but we do want to keep these factors in mind, and we would want to apply them as our final step in making that determination. And really, it's just the recognition that ultimately the federal court has the authority to decide whether or not to exercise supplemental jurisdiction. So even if an additional claim does arise out of a common nucleus of operative fact as the original claim, federal court still has the option under 1367C to decline to hear the case or the claim. Okay, that's your discretionary factors. We can do one more practice problem, 5.0, to just bring all of this together and go through all three steps, kind of how we would apply this if we saw it tested. So here we see Pam, a wheelchair user, needed to buy groceries from the local store. However, the store did not have a wheelchair accessible point of entry. When Pam attempted to enter the store through the only point of entry available, a store patron negligently ran into Pam, causing Pam to sustain injury. Pam filed a lawsuit in federal court alleging discrimination against the store based on probably disability under federal law, and negligence against the patron under state law for bumping into her. All parties are citizens of Texas. Does the federal court have subject matter jurisdiction over the claims? So the first thing we would do, if we're asked in the call of the question, does the federal court have subject matter jurisdiction over the claims? We think about federal question and diversity over both claims. So you could start with the discrimination claim, right? If we're drawing this up, if we're going to map out this lawsuit, you can start with the ADA violation, the federal claim, right? Americans with Disabilities Act is probably what we're getting at here. An ADA violation, federal law claim, we know satisfies Section 1331 federal question jurisdiction, right? The Americans with Disability Act creates the cause of action that Pam is suing under. So we know that Pam's claim arises under federal law. Pam's claim against the store, right, basically for this ADA violation satisfies Section 1331 federal question jurisdiction. So no problem yet, right? Obviously, the federal court can hear the ADA claim against the store. That arises under federal law. They have subject matter jurisdiction to hear and decide that case. But we know Pam files a second claim, right, against a different defendant, against the store patron. Pam files a state law negligence claim against that patron, okay, in federal court. Does the federal court have an independent basis for jurisdiction over that second claim against the patron? Well, does it have federal question jurisdiction over a state law negligence claim that does not arise under federal law? No. Do they have diversity jurisdiction over the claim? No, right? Plaintiff and defendant are both citizens of Texas, so the federal court cannot exercise federal question jurisdiction over the state law negligence claim against the patron, and the federal court cannot exercise diversity jurisdiction over the state law negligence claim against the patron because the parties share citizenship. They're not diverse. Okay, so this obviously raises supplemental jurisdiction as an issue. We have one claim that the federal court has subject matter jurisdiction over. The federal law claim for the ADA violation satisfies Section 1331 federal question jurisdiction. And we have an additional claim where the court has no independent basis of federal subject matter jurisdiction over. So the question is, can they apply supplemental jurisdiction over that state law negligence claim? So to make this determination, we go to 1367A, step 1, right? So we come here and we ask under section 1367A, which is step 1 in our analysis for supplemental jurisdiction, does Pam's claim qualify for supplemental jurisdiction? Remember, to make this determination, we really just have to apply the common nucleus of operative fact test. But here we say Pam's negligence claim qualifies for supplemental jurisdiction if the claim arises from a common nucleus of operative fact with the ADA claim, the federal law claim, such that Pam would be expected to try the negligence claim and the ADA claim in one judicial proceeding. So do these claims form part of the same case or controversy such that Pam would reasonably be expected to try them both in one judicial proceeding? Do the claims arise out of a common nucleus of operative fact? Remember, I always think about this in terms of like, how would you litigate each of these claims, right? So we have a negligence claim. The patron bumps into Pam. But why was Pam using that point of entry in the first place? Because the store didn't have a wheelchair accessible point of entry. So Pam is forced to go into this congested point of entry that's not designed for wheelchair users, and she ultimately gets bumped into by this person, right? So the evidence between those claims is going to overlap a lot, right? It almost arises out of the same occurrence, right? The same nucleus of operative fact. Pam can't use a wheelchair accessible point of entry, has to go into this congested point of entry. This results in her being bumped into. The claims overlap significantly. We have a connection. We have a nexus between those claims. We would say those claims arise out of a common nucleus of operative fact such that Pam would expect reasonably to try them both in one judicial proceeding. So 1367A, we can say that state law claim qualifies for supplemental jurisdiction. Then we'd have to go to step 2. 1367B. Is Pam's negligence claim disqualified for supplemental jurisdiction? This is an obvious no, right? The court's original jurisdiction in this case is based on federal question jurisdiction, not diversity jurisdiction. Therefore, section 1367B does not apply. We just totally skip it, right? Remember, 1367B is only at issue when the court's original jurisdiction is based on diversity. Here, the court's original jurisdiction is based on a federal law claim, right? Section 1331, federal question jurisdiction. So we skip step 2 and we go to step 3. We apply our discretionary factors. Would any of those be at issue here when we're thinking about the discretionary factors from section 1367C? Does the state law negligence claim raise a novel or complex issue of state law? No, right? People bump into each other all the time. Like, this is a common lawsuit people sue for, right? People in crowded areas, whatever, you get bumped into by another person and then there's injury. That's pretty garden variety negligence, right? There's not going to be any novel or complex issues. It's not like we have a Paul's graph fact pattern where, fireworks explode on the train and there's a shockwave and equipment falls and hits something. Like, it's not a fact pattern that raises novel issues. So no. First factor really wouldn't be at issue. Does the state law claim substantially predominate over the federal claim? We don't really have any evidence that would support that. If anything, the federal law claim seems to be more substantial than the state law claim here. Just a patron bumping into someone versus, this store not having a accessible point of entry for wheelchair users. I don't see the state law claim there substantially predominating over the federal law claim. We don't have any evidence that any claims have been dismissed. So no, the third factor wouldn't be at play. The court has not dismissed all the claims over which it had original jurisdiction. Really no exceptional circumstances I can think of here that would, warrant the federal court to decline exercising supplemental jurisdiction. So for all of these reasons, right, the claim qualifies for supplemental jurisdiction because it arises out of a common nucleus of operative fact as the federal law claim. We skip step 2. It's not disqualified because the court's original jurisdiction is based on federal question jurisdiction, not diversity jurisdiction. And step 3, we don't have any compelling reason for the federal court to decline exercising supplemental jurisdiction over the state law claim. So here we would be confident saying, yes, the court has subject matter jurisdiction over both claims. It has federal question jurisdiction over the ADA violation claim, and it can exercise supplemental jurisdiction over the state law claim that arises out of a common nucleus of operative fact as the federal law claim. That's the answer to this question. That is supplemental jurisdiction. So from here, I hope that makes sense of supplemental jurisdiction. From here, we can move on to our final way that a federal court obtains subject matter jurisdiction over a case, and that's going to be removal. But until then, I wish you guys all the absolute best, and I'll see you at our next lesson.